All right, so you filed your divorce, you got your spouse served, 20 to 30 days have passed. Either your spouse hasn't answered, or they just haven't done anything, or they haven't engaged in any negotiation discussion with you. What do you do at this point? At this point, you're going to need to file what's called a request for judicial intervention. This is going to turn an ordinary divorce into a contested divorce. Once your divorce turns contested, you are requesting a judge to be assigned on your case. Once a judge is assigned, you're going to start going through a process of a number of different conferences and hearings. Your first hearing is what's known as a preliminary conference. At a preliminary conference, it is your first time meeting the judge, probably first time being in court for most people. Once you get there, you or your attorney will fill out what's called a preliminary conference order that lists the number of issues that the court is going to have to address, whether it's spousal maintenance, child support, custody, visitation, equitable distribution of assets. Whatever is going on in your case, the court needs to know. They don't know you. They've never met you before. They've never heard a thing about what's happening in your situation. So this is your chance to be heard and to tell the court exactly what is happening. The judge will generally introduce themselves to you. They're going to give you a little bit of a taste of what you could expect. But for the most part, the court is more interested in setting a very clear schedule. The schedule is going to include dates to exchange financial records. It's going to include orders for any appraisals, whether it's for your retirement accounts, any real estate that you might own, or anything else that's relevant. If there's a business that may need to be valued, all of these things have to be accounted for at the preliminary conference. So once you get there, you're going to be with your attorney. You're going to fill out all this information, and you're generally going to have about 60 to 90 days until your next conference. In that time, you have to be ready to gather all of your financial documents, get your affairs in order, get property appraised, and make sure that your case is moving forward. When your spouse is non-responsive, this holds them accountable. If they do not respond to this court-ordered discovery, they will either be compelled to do so at some point by filing a motion or precluded from entering any evidence in their own defense. What does preclusion mean? Once someone is precluded, they cannot enter any evidence that was not submitted as part of discovery. So be ready for that preliminary conference. That is a very important date for you.